when I'm not in trial, but she is, I mean, I got to be a part of it, right? I mean, we're lucky to get to trial.
Yeah.
Sometimes I've been blessed and I've had 3-4 trials in a year, but then the following year you'll have 0.
Right.
It's so cyclical.
Yeah.
And you can never know. And so, gosh, if somebody's going to trial, I need to be a part of that. It gets my juices flowing.
A bigger lesson, a more important thing for a young female lawyer to hear who hasn't had children yet, who is concerned about what that looks like. And it's absolutely achievable. It's all absolutely achievable. And it's been the greatest blessing of my life.
That was always fun with our kids growing up. They were like, well, now, do you get a whole bunch of money when you... Nope.
Our clients do.
Same salary. You don't get it. You just won this case. You don't get anything extra? Nope. Just my salary. The kids could never understand that.
So they're going to be plaintiff's lawyers.
Yeah. I'm sure the plaintiff's lawyer job sounded a lot better to them. A lot better to them.
Howdy, and welcome to the show. Cooper's Code focuses on legal issues and notable practitioners, distilling wisdom so we all achieve the best results for our clients. I'm Miles Cooper, and I'm very excited for this conversation with employment defense world's power couple, Mollie Burks and Michael Laurenson. What I'm hearing, and it's neat to hear, is that one can have a successful practice and be a successful parent.
100%.
Definitely. We put a lot of emphasis on the family stuff, and it does take, obviously, a partnership. You really have to, back each other up and be willing to do anything that needs doing. And the case that we tried together was in San Francisco, so we could both get back by 7 o'clock, even though we're trying a case together, we could get home.
I think that's a perfect segue into talking about the trial that you did together here in San Francisco. Tell us a little bit about that case, and then I want to get down into kind of the mechanics of what it was like to try a case together.
Sure, absolutely. So our client, it was an employment case, but a little bit of a hybrid employment case. The plaintiff in that case had sold his business, smaller business, to our client, who is a marketing company. And as part of that acquisition, they also offered him employment at the company. During the acquisition, the due diligence, there was some financing issues for the soon-to-be plaintiff, employee and then plaintiff, and the company gave him a loan that he had to sign a promissory note. It was all in connection with the sale of his business. He came to work for our client. He did not perform at all. His employment was terminated for that reason. And then he filed a lawsuit that included an age discrimination claim, a breach of contract, wrongful termination, and our client filed a cross complaint for his failure to repay this loan. And
it was Mollie's case, and I had been, helping her with it like we do. We talk and I help, and I'm really good at the graphics and the PowerPoint and stuff. And so and helping with ideas and themes. And so I was familiar with the case, and I don't know, maybe there just came a point where you're just like, you should try it with me. I was like, okay, but I need to be first chair and you're second chair. And she's like, okay, I promise. And so I, formally joined the team, and we, like I always do with all of my trials, I divvy up responsibilities with the person I'm trying the case with. So she knows the case and the client and the facts better. So she's going to do opening, and she's got these witnesses, and I've got the plaintiff and these witnesses, and I'm going to do closing and pick the jury. And so we have our responsibilities, and that helps. And then, being pretty siloed about those responsibilities. I mean, we're bouncing ideas off one another, but, I'm not in her witness preps. She's not in my witness preps. We're kind of getting ready. And then, professionally, she kept Burks as her last name. So I'm Laurenson, she's Burks. Judge Ulmer doesn't know any better that we're married. Nobody knows that we're married. We don't tell anybody. Jurors don't know that we're married. And we did it. And it was, it really actually wasn't that bad. There was only literally like one moment the Friday before trial call when I was working on something that I was responsible for, and she was prepping a really key witness. And she came into my office, 4:30 Friday afternoon, very upset that this guy just wasn't going to cut it. It wasn't going to be ready. He'd worked with them so many prior times and all these hours today, and it's just not going to be there. And I don't know if she's crying, but she's
crying.
She's, teary. And I was like, what are you doing? And I literally said to her, if you were trying this case with Mike Lucy or Steve Ronk, would you be in their office crying about your witness? No, you can't be in my office crying about your witness. This is your witness. It's your problem. I got something I'm working on here. You got to go deal with this problem. And, to her credit, she was like, you're right. And I will. And went and did it. And of course, the guy ended up killing it.
He did great in trial.
He did great. And, not only did we defense the plaintiff claims, and it may have been kind of low-hanging fruit, but we prevailed on our cross-complaint on the promissory note and recovered $200,000, which is, it doesn't really happen in our line of work. We don't, employment defense attorneys, we don't get affirmative relief. We're happy to defense the case. And that was always fun with our kids growing up. They were like, well, now, do you get a whole bunch of money when you? Nope.
Our clients do.
Same salary. You don't get it. You just won this case. You don't get anything extra? Nope. Just my salary. The kids could never understand that.
So they're going to be plaintiff's lawyers.
Yeah. I'm sure the plaintiff's lawyer job sounded a lot better to them. A lot better to them. So they get millions of dollars and they divide it up. But you win, you just get a pat on the back. Yeah.
For anyone who is in that situation, whether it's married or very close in other ways, do you have recommendations on ways that it worked best for you?
So I think we were fortunate having gone into this trial. Gordon Rees has, at least our employment practice group, I can say this with confidence, we have an approach to how we staff cases, and it's pretty consistent. I mean, even coming up from Los Angeles, the way that I saw the San Francisco employment group in the same firm approach staffing, case staffing, and how to approach trial was very similar to how I was taught and raised. And so Mike and I both, in thinking about the trial, how the roles, what you do, how the roles break down, your division of responsibility, we both were raised in that same way. So that was kind of the baseline. And if you don't have that, you want to make sure that is very clearly outlined ahead of time, so that everyone understands what their expectations are. I think it's definitely worthwhile to sit down and have a conversation with someone that you're close with, that you're about to try a case with, about the potential for high emotions to kind of bleed into your professional, what you're trying to do professionally, and how can we build in some safeguards to prevent that. We didn't have that conversation ahead of time, but it made absolute perfect sense to me when Mike said, if I were Steve Ronk right now, this would not be happening. It clicked in my head, but that would have been an obvious conversation to have ahead of time, right? That would be my advice.
I can't add anything to that. That's what we did, and it worked great.
More broadly, as far as your trial practices are concerned, are there certain elements of trial where, I absolutely love this part and I always want to do this? Or the contrary, where, this part is not my favorite and I'd rather, my partner or someone else handle this piece of trial?
I love openings. I love it. The way that we both approach openings this is all about the theme of your case. There's so much preparation that goes into building your opening. the theme, and if you're able to use graphics, sometimes you can't, but and how you tie that, all of your evidence that will come out, the story, how you look at your, because this is again how we both do this, develop your direct examination outline and make sure that your opening that you're building also corresponds with that. I think for someone who's a control freak, that is the part of trial that you have the most control over. So it just really speaks to me.
And I love closings. I love doing the graphics. I love coming up, there's so much more freedom in closing. So I love coming up with the cute ideas and doing the cute things with the graphics. And I think I'm really good at distilling the case and putting the evidence with the jury instructions and the verdict form and delivering it in a, being able to be argumentative. That's, that freedom to be argumentative. I'm really comfortable. And I'm a very firm believer in graphics. And the case so well by that point, and you start putting together those graphics early in the trial. And in fact, the thing I've realized over my career and all the cases I've tried now is there's a way to do this. There's a way to do an opening and employment case. There's a way to do a closing, to the point where, when I sit down to do a closing, the first thing I do is go get the last one and start changing the title and modifying a couple slides, because there's so much in common. You want to have the theme in the beginning. You want to, circle back and tell a little bit of story. Then you want to get into the jury instructions and put the evidence. And a lot of my, we all develop these little gimmicks we have. And, one of mine is a red herring. One time, and it's all about, we all know, it's all about adopting what you learned and heard from others and stealing it and making it your own. And sometime I heard about the red herring story where, in old England, they used to train the hunting dogs by dragging a stinky fish across the fox's trail. And the little baby hunting dogs would have to learn, as they're heading down the fox's trail, they'd have to learn to ignore the smell of the stinky fish and stay on the fox's trail. And that's where it was a herring. And that was where red herring came from. And I would suggest to you, ladies and gentlemen of the jury, that over the past 2 weeks or so, you've had a lot of stinky fish drugged back and forth in front of you, trying to distract you from the truth. But like those little baby foxhounds, you need to keep your eye on the truth. And the truth is, and a lot of those things are red herrings to distract, right? And then I have a slide with a picture of a red herring on it. And I have the 10 things on there that they did during the trial to trick people. And I phrase them in a way that I adopt what the other side is saying. So I phrase it in a way that's almost like devil's advocate-y, like it says, never put him on a performance improvement plan. Like I use their own phrasing. Yeah. And I'm like, that's not what this case is about. This isn't a performance case. This was something else. And so our partner, Allison Cabrera, texted me, and I didn't even know, I had forgotten that she and Mike Bruno were in this trial together. And she texted me and she's like, can you send me your red herring slides? And I went to the last trial and I found them. I sent them and she adopted it to her case and they won. And then I saw her a couple weeks later and she's like, that red herring stuff was amazing. The jury loved that. And it was so fun. The thing about the red herring is it's so fun.
Yeah.
It's so fun.
Yeah.
But it's that ability to do anything. I really embrace that. I remember I had a sales case one time. There was a salesman who was terminated for not being a good salesperson, was not selling enough. and I loved Glenn Ross. And one of my favorite movies of all time, and I loved Alec Baldwin's ABC, Always Be closing speech, right? And so I had my opposing counsel give his, opening statement, his closing argument, reading from flipping pages on a yellow pad, no graphics, no nothing, finishes, and the court judge looks to me, Mr. Laurenson, and I stayed seated and I pressed play. And for the first 2 minutes of my closing, we watched Alec Baldwin's Always Be closing speech from Glenn Ross. I didn't even speak before I played it. And then I stood up and, that's what this case is about. He wasn't closing. And the ability to be able to do that and be creative with closing is so much fun. So I really like closing. And then I always pick the jury just because I don't think I'm very good at it. I think it's hard to be good at. It's probably the hardest thing to do as a trial attorney. But I'm just, I'm comfortable standing in front of people, talking to them, getting them to talk to me. And then I hopefully get enough information out of them that I can rely on the rest of my team because I don't trust my own instincts in that regard. I involve everyone on the team before I, strike somebody. I get, this is the one. I get all five people to buy in because that's very hard for me to think I know whether they're going to be good or not. But I'm good at talking to them and getting information out of them.
Did you win the sales case?
I didn't.
You did not.
I didn't. That's the greatest / hardest, I don't know, thing about being a trial attorney. Winning a case doesn't necessarily have anything at all to do with being the best trial attorney in the courtroom.
You ruined my punchline. I was going to ask if you sent the plaintiff's lawyer a set of steak knives at the end. But this is an important lesson that people should hear.
It keeps you humble. What I like to say, and it sounds a little braggy, but it's true. I have not lost a case. Well, that's not true. I lost a case to Ed Nevin, our colleague in Aboda, one of the most amazing trial attorneys ever. I lost a case to him when I was like a 7th year attorney up in Humboldt. And obviously he beat me fair and square because he's an exceptional attorney. But it's not too much of an exaggeration to say that the other cases that I lost, I was a better trial attorney than the other attorney. All my witnesses did better than I expected. I kept out all the evidence I wanted to keep out. I got in all the evidence I wanted to keep in. I was happy at the end, and I lost. It really keeps you humble. It keeps you from getting too big for your britches. You can think you're some amazing trial attorney. It only takes one of those and having to dust yourself off and get back in there. It really keeps you humble.
It also helps you to be actually a better advocate and a better servant to your clients because you can explain in very real terms what a jury does. And oftentimes there is no logic behind what a jury does. And that is a really important lesson to learn. Yeah.
It's certainly not something that you, want to brag about. It's probably not even something I should say in this podcast, but I've been to punitive damages phase 2 3 times. There's people in the world that are never going to sniff that.
Yeah.
I know exactly what to do in phase 2. Now, you don't ever want to be in phase 2.
Well, we do.
But I got people throughout the firm calling me when they get a lose in phase 1 because they don't know what the heck's going to happen in phase 2. And I do. And I tell them exactly what to do and what elements of the case to argue and how to handle it and how uncomfortable it's going to be. I've been there.
Yeah.
It's probably the most uncomfortable place you could be as a trial attorney. But like you say, to know that, to have that experience and that knowledge, it's only going to happen if you lose phase 1. And I think having been there, like you say, being able to talk to clients and serve your clients better, having been there, that's important.
Yeah.
But it would have been better to win. Certainly, I'm sure.
Since we're on the trial piece, and since anyone who knows anything about your history, Mike, is going to want to hear about the French Laundry case, I feel that now would be an appropriate time.
That'd be great.
It's the kind of case that you can dine out on, right?
You certainly can. It was certainly the best thing that ever happened to me professionally. And again, it only came about, this was my partner Mike Bruno's case. He had it from inception, and it was a big case and a big deal. And they wanted many, many millions of dollars that my client, the French Laundry, the insurance company, was not going to pay.
And backing it up, just so people who are coming in midway understand what we're talking about, this was a pregnancy discrimination case. A woman who had worked at Per Se in New York. Jeff Thomas Keller, they encourage people to, move around and work at different places and come from the Per Se and learn at the French Laundry or vice versa. So there's a lot of cross-pollination in his restaurants. It's encouraged. And this woman was thinking she wanted to be in California for some reason or something. So she came out here and staged, practiced at the French Laundry and thought she had received a positive reception and thought she was going to be able to come work at the French Laundry. And, they ultimately declined. But they did not decline before learning that she was pregnant. Mm-hmm. And so, the obvious argument was that they only declined because they learned that she was pregnant. And, what had been said before and was it promised? And so this had been Mike Bruno's case from the beginning. And again, Mike Bruno was smart enough and comfortable, secure enough in his own place in the world to know that he needed help. Just so that people really get the wisdom on that, and that is that work with good colleagues, be willing to let go of your ego and bring people in when it's the right time.
Absolutely. So he's got a case where he's representing the French Laundry, and his client is Thomas Keller, and he could have kept that to himself, right? That's a pretty special thing that he could have kept to himself, but he was big enough and smart enough to know that he could use some help. And so he asked me to try it with him, and also, willing to just kind of let me kind of be like the first chair. We were more like co-equals, but, do some first chair type stuff. And so I joined the case maybe 3 months before trial and had to learn the case and meet everybody. But the super cool aspect of it was because she had been working at Per Se and had, come out to the French Laundry, there were a lot of witnesses at Per Se. So a month before trial, we went back to New York.
This must have been challenging duty for you, Mollie.
Yeah.
Very challenging.
We go back to New York so that I can meet with and prepare the Per Se witnesses who are going to come out and testify in trial. So the GM of Per Se and so we're back behind the curtain in Per Se and meeting people, and preparing them that day. And so we tried the case, a month or two later in Napa, me and Mike Bruno, and took most of a month and sitting, and, Thomas Keller was in court sitting next to me every day. And it was a super hard trial. There were 5 attorneys on the other side, vigorously advocating for their client. And literally every day was a battle. I mean, the hardest experience of my life. There was some bad evidence. We could have, trial went okay, but again, it was such a battle that we really didn't know.
My memory is there was a pretty devastating email.
So when the GM, who again, according to him, never intended to hire her, found out she was pregnant, he emailed the HR lady and said, something, I forget the quote now, but it was something to the effect of, just found out she's pregnant. What are we going to do now or something, and they're like, smoking gun.
Yeah.
I think they probably called it a smoking gun.
Yeah.
And it was bad. And so we wouldn't have been surprised at all had we lost. And I did closing, and I remember it had been in the papers that it was going on. And so a lot of folks came up from the Bay Area for my closing. The courtroom was full, and a lot of my colleagues on the plaintiff's bar were there and, kind of waved to them and for my closing. And we were lucky enough to win. And I'll never forget that moment when we get the defense verdict, and Thomas and I look at each other with tears in our eyes and the big bro hugs all around, and it was an incredible experience. And my closing argument was quoted in, quotes from my closing in the New York Times. And for like 6 months after there, I couldn't pay for dinner anywhere in town, and went to the French Laundry a couple times. And then wouldn't you know it, this was July of 2019 was the verdict. Wouldn't you know it, March 2020 happens. COVID hits, ruins the best professional hookup I've ever had in my life, and never been the same again. So it was pretty great. And he's a wonderful man, just so lucky to have really gotten to know him personally, an extraordinary man. And certainly we only won that trial because of his reputation in that community and who he is, and taking the stand, testifying how he did. I mean, against that evidence, that's the only explanation I can come up with for how we could win that case, was the kind of quality human being he is. So being able to get to know him was pretty special.
This is a good opportunity for me to ask you, because I've used the phrase thinking partner. I presume when Mike is either coming home or calling in, that he's bantering about the case with you. What role do you play in helping him, bring out the best in what he's doing?
He will go through his examination questions with me. He will perform his opening for me. He will show me the graphics. Mike, he was talking about closing argument a little while ago, and he is so creative. That's such a process for him that he literally dreams about it. He wakes up in the morning and he will have his closing done, and he wakes up and he's thought of another slide that needs to be added. We talk about every single one of these cases.
And I will do the same with her when she's coming up for trial, and help her. And there's been many times when we've gone on a walk or something, a hike, and we're talking about her case, and I'm having these ideas. And we'll come back from this walk, and I'll sit down and I'll bang out 7 slides for her closing in 45 minutes that I've done on the walk, in her case. Yeah. Because it just, so we help each other like that. And I just I really love trial. I love talking about trial. I love teaching trial stuff. I love helping people with trial. I love being in trial. And so when I'm not in trial, but she is, I gotta be a part of it, right? We're lucky to get to trial. Yeah. Sometimes I've been blessed and I've had 3-4 trials in a year, but then the following year you'll have 0. Right. It's so cyclical. Yeah. And you can never know. And so, gosh, if somebody's going to trial, I need to be a part of that. It gets my juices flowing.
Shifting a little bit, and this is the shift back to you, Mollie. You earlier on in the conversation, you talked about how you enjoy complex wage and hour and PAGA and other cases with that flavor.
Yes.
We've seen Mike just now get really passionate about the some of the work that he's doing. What is it about those cases that drive you?
Oftentimes, wage and hour class action case has the potential to destroy a company. Okay. And even if it's a Fortune 500 company, some of these cases are still their worst legal problem that they're dealing with because of the scale and the scope and the difficulty in terms of operating a business in the state of California and the labor code. I very much enjoy. I think this is the single most thing about the practice of law that I love is helping people with their worst problems. I like to hold your hand and, walk you through and help come up with a solution on the other side of all of this. They also need counseling to deal with the problems, like the practical, how do we practically deal with this aside from how are we going to practically deal with the litigation. And so I get a lot of, I find a lot of meaning in that.
High stakes.
Very much.
Is that part of the draw?
Oh, absolutely.
Yeah.
Yeah, these cases, all of them, these cases are worth $10 or more $1 million, all of them.
Yeah.
And
in a worst case scenario kind of exposure sense, 8-figure, 9-figure.
Generally, when I think of employment, because I come from small world, I think of smaller, like the cases that you're talking about, Mike. How did you end up going from what I think of as the old-timey employment cases to these big, higher exposure cases?
So I think it was a little bit of being in the right place at the right time. As an employment lawyer, 20 years ago, you learned about the labor code. You learned about wage claims because oftentimes your single plaintiff discrimination, wrongful termination case may also have some wage claims. And we would also handle administrative claims in front of the labor commissioner's office. So I gained that knowledge around the labor code and how it works. And it's a vast set of it's a huge set of laws, really, when you compare it to other states. And I just became very comfortable with that.
And then those claims boomed.
Yeah, in the early 2000s, PAGA passed originally in 2004. And for the first 6 years, up until 2010, PAGA wasn't really much of anything. It was kind of like a tag-along claim. And then then there were a couple of big court decisions, a California Supreme Court decision and a U.S. Supreme Court decision that dealt with class action waivers. And the California Supreme Court said class action waivers don't apply to representative actions. And the U.S. Supreme Court said class action waivers can be enforceable in an arbitration agreement for class claims. And so that resulted in this huge spike of PAGA litigation.
Okay.
And I just happened to be there at that time.
It's like gravitating to your thing, and we're good at it, right?
Yes.
I mean, we're exceptional at it, and getting your arms around those massive cases, getting your arms around the data and getting them figured out and resolved.
And calming people
and
down.
liking it and liking
people
it.
down.
Like she said, I hate them. I mean, I will, if I could never have another, wage and hour case for the rest of my life, I'd be a happy man. I get them in and give them all to her. I want my individual plaintiff cases with a story and, I hate these things, but she's exceptional at them, and there's way more of that work almost out there and it's way higher rate and, it's way more important to companies than the kind of cases that I defend, one person.
Yeah. Yeah. As we come into kind of the final pieces of things, I always want to make sure that folks have had an opportunity to share everything that they feel is valuable. And I know that packing decades of knowledge into an hour and a half space can be very challenging. Are there pieces that we haven't touched on that you think it would be helpful for our listeners to hear?
I really appreciate the opportunity to do this because I'm really proud of what we've accomplished together.
Yeah.
It's, I think when we started out together, we could barely scrape enough money together to buy a house and wouldn't have been able to buy a house together. But I had been in the Navy 25 years ago at that point. And my dad goes, "Why don't you see about a VA loan?" And I'm like, VA loan? I was in the Navy 20 years ago. Well, I don't even know what it turns out. I could qualify for a VA loan and we could buy $1 million house.
The interest rate was incredible.
With a ludicrous interest rate.
Huh.
And so, it was, and those first couple of years were hard to put our family together. I had only raised 2 girls. All of a sudden, I'm not just a stepfather, but I'm a stepfather to a boy, a 9-year-old boy. Up to that point, I hated all the boys that were at my daughter's birthday parties. The boys were jerks. I'd hated them, and now all of a sudden I'm a dad to one, and I have to be a stepdad to one. And so those were hard. Those first 3 years were hard, even financially and for our family. And we, just worked super hard. And I don't know, 12 years later, it's turned out pretty darn good. And I'm just really proud of what we've achieved. That's not something your listeners would care about, but I just wanted to say that. Well, it's not a lesson for anybody, but
I think it's a lesson for lawyers. I truly think it's a lesson for lawyers. And I think maybe even a bigger lesson, more important thing for a young female lawyer to hear who hasn't had children yet, who is concerned about what that looks like. And it's absolutely achievable. It's all absolutely achievable. And it's been the greatest blessing of my life.
What I hear within there is that we rise to the occasion and that the two of you have done that.
It's got to be 50-50. We talk about having, I learned this from my parents. Parents, both public school teachers, and just really great at modeling, you are equals and everybody can do anything in that household. And, and they did everything for each other. And I really felt that way. And it's been very important to us. And so I do think, like Mollie said earlier, neither of us would have achieved what we have achieved without having had somebody like we each had to help us get there, right? You can't achieve this on your own with somebody sitting back home who you don't respect and is not an equal partner. I mean, you only get to where we've gotten and achieve what we've achieved if you're all in for the other person.
Absolutely. One of the things that I'm most proud of in my life is that when my children were at home before they left the house and went off to college, that we had a family dinner together every night. Every weeknight, we would sit down at the table and eat together. And I would cook. And, oftentimes that was something that I put in the slow cooker in the morning before we left. And then we would have dinner that night. But even that is a perfect example
and unusual.
The importance of the 50-50, because I would not have been able to do that if I didn't have my dishwasher sous chef here to ensure that I could cook.
I want to thank both of you for coming. It was a real joy to sit down with both of you.
Thank you, Miles. It was a great time.
Thank you so much, Miles.
And thank you for listening today. Please email us at podcast@coopers.law with questions, comments, feedback, and suggestions for who we should have on the show. Like what you heard? Share us with a colleague and leave us a 5-star review on your podcast platform of choice. To all of you doing justice out there, happy hunting.